Indian constitutional law, the new challenges. Question. Distinguish between judicial activism and judicial restraint. Question. Explain the growth of public interest litigation, PIL, in India. Question. Write a note on constitutional harmony and balance between fundamental rights and directive principles of state policy. Question. Explain briefly the brain drain by foreign education market. Question. Explain the dichotomy between secularism vis-a-vis religious freedom. Question. Explain doctrine of separation of powers. Distinguish between judicial activism and judicial restraint. Judicial activism versus judicial restraint. Judicial activism and judicial restraint are true opposite approaches. Judicial activism and judicial restraint, which are very relevant in the United States, are related to the judicial system of a country, and they are a check against the fraudulent use of powers of the government or any constitutional body. Judicial activism is the interpretation of the Constitution to advocate contemporary values and conditions. On the other hand, judicial restraint is limiting the powers of the judges to strike down a law. In judicial restraint, the court should uphold all acts of the Congress and the state legislatures unless they are violating the Constitution of the country. In judicial restraint, the courts generally defer to interpretations of the Constitution by the Congress or any other constitutional body. In the matter of judicial activism, the judges are required to use their power to correct any injustice, especially when the other constitutional bodies are not acting. This means that judicial activism has a great role in formulating social policies on issues like protection of rights of an individual, civil rights, public morality, and political unfairness. Judicial restraint and judicial activism have different goals. Judicial restraint helps in preserving a balance among the three branches of government: judiciary, executive, and legislative. In this case, the judges and the court encourage reviewing an existing law rather than modifying the existing law. When talking about the goals or powers of judicial activism, it gives the power to overrule certain acts or judgments. For example, the Supreme Court or an appellate court can reverse some previous decisions if they were faulty. This judicial system also acts as checks and balances and prevents the three branches of government, judiciary, executive and legislative, from becoming powerful. Judicial activism is the interpretation of the Constitution to advocate contemporary values and conditions. Judicial restraint is limiting the powers of the judges to strike down a law. In judicial restraint, the court should uphold all acts of the Congress and the state legislatures unless they are violating the Constitution of the country. In the matter of judicial activism, the judges are required to use their power to correct any injustice, especially when the other constitutional bodies are not acting. Judicial activism has a great role in formulating social policies on issues like protection of rights of an individual, civil rights, public morality, and political unfairness. When talking about the goals or powers of judicial activism, it gives the power to overrule certain acts or judgments. For example, the Supreme Court or an appellate court can reverse some previous decisions if they were faulty. Explain the growth of public interest litigation, PIL, in India. Introduction. PIL means litigation filed for the protection of public interest, like pollution, terrorism, road safety, construction hazards, etc. Any matter where the interest of the public at large is affected is often redressed by filing a public interest litigation. The expression, public interest litigation, has been borrowed from American jurisprudence, where it was designed to supply representation to previously unrepresented like the poor, the racial minorities, unorganized consumers, citizens who were hooked on the environmental issues, etc. Public interest litigation is the power given to the general public by courts. The person filing the petition must convince the court that the petition is being filed for the public interest and not for personal reasons. The court itself may take suo motu cognizance of the cases, may commence on the petition of any public-spirited person. Some of the matters which are considered under PIL are bonded labor matters, neglected children, non-payment of minimum wages to workers and exploitation of workers, atrocities on women, environmental pollution and disturbance of ecological balance, food adulteration, maintenance of heritage and culture, origin and evolution of PIL in India. The concept of public interest litigation was introduced for the first time in India by Justice Krishna Iyer in 1976 in the case of Mumbai Kamagar Sabha v. Abdul Tai. The first ever reported case of public interest litigation was Hussainara Khatun v. the State of Bihar, 1979, that focused on the inhumane conditions of prisons and under trials, which led to the acquittal of about 40,000 under trials prisoners. The right to speedy justice emerged as a fundamental right that was not given to those prisoners. A similar set pattern was adopted in later cases. A new period of public interest litigation movement was started by Justice P.N. Bhagwati in the case of S.P. Gupta v. Union of India. Some of the landmark judgments on PIL were Indian Banks Association, Bombay and Ors. V.M.S. Devkala Consultancy Service and Ors. M.C. Mehta v. Union of India. Vishakha v. the State of Rajasthan. Facts responsible for the growth of PIL in India. The character of the Indian Constitution. India features a written constitution which through Part 3, Fundamental Rights, and Part 4, Directive Principles of State Policy, provides a framework for regulating relations between the state and its citizens and between citizens inter se. The liberal interpretation of locus standi also means that any person can apply to the court on the behalf of the people who are financially or physically unable to return before they are helped. Judges themselves have in some cases initiated motu actions supporting newspaper articles or letters received. Although social and economic rights given within the Indian Constitution under Part 4 aren't legally enforceable, courts have creatively read these into fundamental rights, thereby making them judicially enforceable. For instance, the right to life in Article 21 has been expanded to include the right to free legal aid, right to live with dignity, right to education, etc. Judicial innovations to assist the poor and marginalized. In the Bandhuya Mukti Morcha case, the Supreme Court put the burden of proof on the respondent, stating it might treat every case of forced labor as a case of bondage unless proven otherwise by the employer. Similarly, in the case of Asiad workers, Justice P.N. Bhagwati held that anyone getting a wage can approach the Supreme Court directly without going to the Labour Commissioner and lower courts. In PIL cases where the petitioner isn't in a position to supply all the required evidence, either because it's voluminous or because the parties are weak socially or economically, courts have appointed commissions to gather information on facts and present it before the bench. Drawbacks related to public interest litigation. A PIL may give rise to the matter of competing rights. When the court orders the closure of a polluting industry, the rights and interests of the workers are also being violated as their only source of livelihood is being snatched away from them, and this may not be taken into account by the court. It's for the reason that people can misuse and file frivolous PILs motivated by personal and selfish reasons or malice. The courts have reiterated time and again that PIL isn't personal interest litigation for corporate, personal, and political gains. This results in the overburdening of the courts. In the process of solving socio-economic issues or a drug related to the protection of the environment, the judiciary may in certain cases exercise judicial overreach through TPILs. There is an inordinate delay in the disposal of PIL cases, especially matters involving the poor and disadvantaged. This defeats the entire purpose of speedy justice and dilutes the importance of judgment. Conclusion. Public interest litigation has departed from the normal system of litigation and caused a system that involves initiating an action to enforce the interest of the general public at large. Over the years, it's become a potent tool for the poor, illiterate and underprivileged to have access to the courts and seek judicial redress by filing an application under Article 226 to the Supreme Court and Article 32 to the Supreme Court. Therefore, PIL has democratized access to justice by relaxing the rule of locus standi. Thus, any public-spirited person or social activist or group can now approach the court on behalf of a particular group or class of persons, especially the oppressed and marginalized. The main reason why PIL has flourished in India is that the Constitution of India through its Part 3, Fundamental Rights, and Part 4, Directive Principles of State Policy, provides a framework to manage the relationship between the state and the citizens and also between citizens. The accountability of the government towards the rights and interests of the poor and disadvantaged has increased in PIL within the country. The relaxation of the normal rule of locus standi enables a person to approach the court and represent those that are socio-economically disadvantaged and unable to get redressal. Therefore, PIL has been a crucial tool in bringing about social change, upholding the rule of law enshrined under Article 14, and thereby creating a fragile balance between law and justice. Right ante on constitutional harmony and balance between fundamental rights and directive principles of state policy. Introduction. The fundamental rights are enshrined in Part 3 of the Constitution starting from Article 12 to Article 35, and it is believed that the framers of the Constitution in this regard have rightly derived their inspiration from the Constitution of the United States, i.e. Bill of Rights. The rights thereby enshrined in Part 3 of the Constitution encompasses in itself an elongated and comprehensive list of justiciable fundamental rights that can be enforced by the ordinary courts of the country. These fundamental rights contained in Part 3 of our Constitution are much more extensive and elaborative than any other country of the world, even more elaborative from where they have been borrowed, USA. On the other hand of this article, we will explore that the directive principles of state policy, the herein referred to as DPSP, are encompassed in Part 4 of the Constitution of India from Article 35 to 51. It is evident at this very stage that the makers of the Constitution of India in respect to Part 4 have derived and borrowed the idea and the concept of having the directive principles from Section 45 of the Irish Constitution of 1937, which in turn have copied it from the Spanish Constitution. These directive principles of the state policy, or novel features, as termed by Dr. B.R. Ambedkar, symbolize and directs the state, as defined in Article 12 of the Constitution, with ideals and recommendations that should be kept in mind while framing policies and enacting laws. But unlike the former, it stands unjustifiable in nature. Both the directive principles of the fundamental rights comprise the philosophy of the Constitution. Now, we will discuss in this part of the article Part 3 and Part 4 of the Constitution much more elaboratively. Fundamental Rights, Part 3. As discussed earlier in this article, these justiciable rights are enshrined in Part 3 of the Constitution of India, Article 12 to Article 35, and are called and named fundamental because of two significant reasons. One, firstly, these rights are guaranteed and protected by the Constitution of the country, which is the fundamental law of the land. Two, secondly, they become fundamental in the sense that they are most essential for the all-round material, intellectual, moral, and spiritual development of an individual. 1. Right to equality, Article 14 to 18, which entails in itself that everyone stands equal before the law and equal treatment should be given to everyone, thereby implying a complete prohibition of discrimination founded on the grounds of race, caste, creed, or gender. Initially and originally there were about 7 fundamental rights, but after the abolition of Zamindari Act 1950, their number was reduced to about 6, which are as follows. 1. Right to freedom, Article 19 to 22. Each individual has the right to freedom to form an association, to peacefully assemble to practice any profession, and carry on any trade, occupation, or business. Contains one of the most significant right, i.e. right to life and liberty, Article 21. Protection and rights to an accused in respect to arrest and detention for conviction of any offense under the penal code of the country. Right against exploitation, Article 23 and 24. This article entails in themselves important and rights such as the prohibition of child labor or forced labor and human trafficking. Right to freedom of religion, Article 25. Article 28. This specific right in the Constitution is of utmost importance in a country like India where there is a huge diversity of religion. This right provides the citizens with the freedom to follow and practice any religion and most importantly grants freedom of conscience to an individual. The rights under this head also specifically provide a clause concerning paying taxes for religious purposes. Cultural and educational rights, Article 29 and Article 30. These rights entailed in Part 3 provides protection to different languages and varieties of culture present in India and additionally protects the rights and culture of minorities, the right institutions to establish and administer educational institutions, etc. Right to seek constitutional remedies, Article 32. As described by Dr. Ambedkar, the heart and soul of the Indian Constitution, these remedies are available to any individual whose fundamental right just violated, and these rights enshrined in the Constitution empowers the Supreme Court of India to issue 5 types of writs. However, the right to property was deleted from the aforementioned list of fundamental rights by the 44th Amendment Act, 1978, and thereby this amendment made the right to property a non-fundamental constitutional right under Article 300-A in Part 12 of the Constitution. Directive Principles of State Policy, Part 4. The Directive Principle of State Policy or DPSP as enumerated in Part 4 of the Constitution as discussed formerly in this article are the constitutional directives or recommendations to the state as far as the cases of legislative, administrative and executive matters to keep in mind the ideals therein mentioned while formulating and enacting laws. The significance of these directives becomes evident from the fact that these directive principles at numerous instances help the court of law, though non-justiciable in nature, to determine the constitutional validity of a law. These directives are often classified into three broad categories. 1. Socialistic principles, for e.g. Article 38, to promote the welfare of the people by securing a social order permeated by justice, social, economic and political, and thereby to minimize any types of inequalities, be it income, status and opportunities. 1. Gandhian principles. These principles characterize the program for reconstruction as enunciated by the father of the nation, Mahatma Gandhi, during the national movement and struggle. For e.g. Article 40, to organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-government. 1. Liberal intellectual principles. These DPSPs entail in themselves some characteristics of the ideology of liberalism. For e.g. Article 50, which further imposes an obligation upon the state to separate judiciary from the executive in the public services of the state. The classification of the directive principles as stated above in this article is not expressly present or made by the Constitution, but however, on the basis of its content, the same has been classified into three broad categories. Significance of the directive principles. These directive principles, despite having been criticized by eminent economists like K.T. Shah as a check from a bank, payable only when resources of the bank permit so, for having no legal sanction and being illogically arranged, and even by former Finance Minister T.T. Krishnamachari, 1956 to 1958, as a veritable dustbin of sentiments. These directive principles in the contemporary times cannot be construed as irrelevant accompaniment. As stated by Justice Chugla, the former Chief Justice of India, these principles, if implemented well and fully carried out, can make our country indeed heaven on earth. The directive principles are auxiliary and can even be considered as subsidiary to the fundamental rights, as they are aimed at and intended to fill in the vacuum present in Part 3 by providing economic and social rights. They simplify and provide a kind of stability and permanency in domestic and foreign strategies of the government or despite changes that occur to the disposition. DPSPs provide the citizens of the country with a quantitative scale to measure the performance of the government and provide them with effective feedback on where it lacks. Conflict between directive principles and fundamental rights. It becomes pertinent to note at this point, even though both the directive principles of state policy and the fundamental rights appear as constitutionally distinct, when we trace back their historical origin, we find that both have originated from a common origin. There was no distinction between the positive and negative obligations of the state, but it was the Constituent Assembly that separated them. We find both the above-mentioned fundamental right and rights as intimate and interlacing parts of the Indian Constitution. The conflict between the DPSPs and fundamental rights seems not to be a novice situation. The character, though, may be similar, but points of conflict even today in the contemporary times rests at the following points. 1. Justiciability of the fundamental rights and the non-justiciable character of the DPSP. 1. Moral obligation and duty casted upon the state to implement the directive principles as per Article 37 has also raised a serious point of contravention since the inception of the Constitution and Part 3 and Part 4. In numerous early cases, the Supreme Court ruled out that the directive principles could not supersede a fundamental right present in Part 3 of the Constitution. However, The position of the same became clear when the Supreme Court took a view in the case of State of Madras v. Srimati Champakam Dorai Rajan. In this case, the Supreme Court ruled that since fundamental rights are enforceable and directive principles are not, so the fundamental rights would prevail over the latter and have to run as a subsidiary to the fundamental rights. However, the situation subsequently changed in 1967 by the Supreme Court itself in the case of IC Golkanath v. State of Punjab, whereby the Supreme Court held that the fundamental rights present in Part 3 of the Constitution are sacrosanct and thereby cannot be amended for implementation of the directive principles of state policy. Relationship between fundamental rights and directive principles of state policy. The relationship between Part 3 and Part 4 is the one that is not a novice one and was discussed by the constitutional advisor Sir B. N. Roy, who advocated the idea that the rights of an individual on the basis of their nature can be divided into 1. Justiciable rights, 1. Non-justiciable rights. The list of justiciable rights was engulfed in Part 3 while the non-justiciable one became a member of Part 4 of the Constitution. At times and again, these directive principles are used by the judiciary to determine the constitutional validity of any legislation when it is found to be in conflict with the fundamental rights or Part 3 of the Constitution. The first case we are going to discuss in this light is of Sajjan Singh v. State of Rajasthan of 1964, where the obiter dicta laid down by Justice Madhukar became apposite. Even the fundamental rights enshrined in Part 3 were taken as unalterable. The much-needed dynamism may be, according to him, achieved by a proper interpretation of the fundamental rights in light of the directive principles. Further, he observed that the Part 4 is fundamental in the governance of the country and the provision relating to Part 3 must be interpreted harmoniously with these principles. As discussed above in the case of Champakam Dorai Rajan, Supra, it was held by the Supreme Court that the fundamental rights would be reduced to a mere rope of sand if they were to be overruled or superseded by the directive principles of state policy. Also, as we discussed earlier in this article while deliberating on the case of IC Golkanath, Supra, Honorable Justice Subba Rao of the Apex Court accentuated that the fundamental rights and the directive principles of state policy together form an integrated scheme which is elastic enough to respond to the changing needs of the society. On a similar note, in Bijoya Cotton Mills v. State of West Bengal, the Supreme Court views regarding the same. 1. In a case of conflict between the rights of an individual and a law that particularly aims at the implementation of socio-economic policies in furtherance of the directive principles, the weight would be accorded to the latter. 1. Every act or legislation enacted in fulfillment of the directive principles should be construed as one professing in the public interest or as a reasonable restriction to Part 3 of the Constitution. Doctrine of harmonious construction and relevant case laws. The doctrine of harmonious construction as a new technique of interpretation was inducted and innovated by the Supreme Court in the case of Qureshi Mohg v. State of Bihar, where the court stated that the Constitution has to be construed harmoniously. The directive principles must be implemented in such a way that it does not take away or encroach upon the fundamental rights of citizens. The courts should adopt the principles of harmonious construction and attempt to give effect to both Part 3 and Part 4 of the Constitution. In Re. Kerala Education Bill case of 1958, Chief Justice S.R. Das held that while affirming the primacy of fundamental rights over the directive principles, nevertheless, in determining the scope and ambit of fundamental rights relied upon by or on behalf of any person or body, the court may not entirely ignore the DPSPs laid down in Part 4 of the Constitution but should adopt the principle of harmonious construction and should attempt to give to both as far as possible. The Supreme Court then began to proclaim that there exists no conflict between the fundamental rights and directive principles. Both stand supplementary and complementary to each other. The above stand was taken by the Apex Court in the case of Chandra Bhavan Boarding and Lodging v. State of Mysore. Since then, the Supreme Court of India in the plethora of cases has started to reiterate the point that the judicial attitude towards both DPSPs and fundamental rights is co-equal. In 1973, in the landmark case of Keswananda Bharti v. State of Kerala, Justice K.S. had duly observed that the fundamental rights and directive principles constitute the conscience of the Constitution, while Justice Shalat and Grover observed that both these parts, 3 and 4, have to be balanced and harmonized. At various instances and in a catena of cases, the courts have utilized the above mentioned the doctrine of harmonious constructions while pronouncing judgments relating to Part 3 and Part 4 of the Constitution. On a similar note, the Honorable Supreme Court in the case of State of Kerala v. N.M. Thomas held that both the directive principles and the fundamental rights should be construed in harmony with each other and every effort should be made by respective courts to resolve any apparent inconsistency that exists between them. Justice Chandrachud in the landmark case of Minerva Mills v. Union of India observed, fundamental rights are not an end in themselves but are means to an end. Landmark aforesaid end is specified in the directive principles. In the paras 56 and 57 of the same judgment, it was also duly held that harmony and balance between the fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. From the above one can lucidly infer that the fundamental rights enshrined in Part 3 can be considered to be the means to achieve several goals that are thereby enshrined in Part 4 and even, at various instances, the fundamental rights is interpreted in light of non-justiciable directive principles of state policy. The same becomes pertinent when we look in the case of Bandhu Mukti Morcha case where the bench headed by Justice P. N. Bhagwati in page 163 of the same judgment, has expressly mentioned, the right to live human dignity, free from exploitation enshrined under Article 21 derives its life and breath from the directive principles of state policy and particularly clauses E and F of Article 39 and Article 41 and 42. The inextricable and entangled relation between Part 3, Fundamental Rights, and Part 4, Directive Principles of State Policy, was even recognized by the legislature in the 86th Constitutional Amendment Act of 2002, where the right to education earlier and originally the element of Part 4 of the Constitution was raised to the fundamental right enshrined under Article 2(1) of Part 3 of the Constitution. These directive principles of state policy are fundamental in the governance of the country. They must therefore be regarded as equally fundamental to understanding and interpretation of the meaning and content of fundamental rights. The aforesaid view was taken by the Supreme Court in the case of Olga Tellis. Recently, in the case of Charukurrana v. Union of India of 2015, the Supreme Court of India again highlighted the importance of their existence, Part 3 and Part 4, by observing that fundamental rights and the directive principles are the two wheels of the chariot establishing the egalitarian social order. Conclusion. In an overview, it becomes apparent or ostensible to note that the view of the judiciary regarding the relationship between the fundamental rights and the directive principles of state policy is the one that is subjected and has undergone gradual transformations from the case of 1951 of Srimati Champakam Dorai Rajan, where the Supreme Court accorded supremacy to the fundamental rights over the directive principles to making a harmony and balance between the two, Part 3 and Part 4, an essential feature of the basic structure of the Constitution. Today, we can manifestly observe that Part 3 at times necessarily have to be interpreted in the light of the directive principles, and the codependence and liaison between the two are increasing day by day. Conclusively, it can be clearly inferred from the judgments as mentioned above that the approach of our judicial system towards the fundamental rights and directive principles have been an integrative one, and time and again, the judiciary in its judgment has employed the principle of harmonious construction. Explain briefly the brain drain by foreign education market. What is brain drain? Brain drain is a slang term that indicates a substantial immigration or migration of individuals. A brain drain can result from turmoil within a nation, the existence of favorable professional opportunities in other countries, or a desire to seek a higher standard of living. In addition to occurring geographically, brain drain may also occur at the organizational or industrial levels when workers perceive better pay, benefits, or upward mobility within another company or industry. Understanding brain drain. As noted above, brain drain is the movement of people from one area to another. Brain drain often occurs between countries and cities where they can find better opportunities. They may move to look for work or a better standard of living. Brain drain can also refer to the movement of professionals between corporations and or industries for better pay or opportunities. Brain drain causes countries, industries, and organizations to lose a core portion of valuable individuals. The term is often used to describe the departure of certain professionals, including groups of doctors, healthcare workers, scientists, engineers, or financial professionals. When these people leave, the places they leave are harmed in two main ways. One, expertise is lost with each immigrant, diminishing the supply of that profession. One, the country's economy is harmed because each professional represents surplus spending units. Professionals often earn large salaries, so their departure reduces consumer spending in that region or the country overall. Geographic, organizational, and industrial brain drain. Brain drain can occur on several levels: geographic, organizational, and industrial brain drain. Geographic brain drain. Geographic brain drain happens when talented professionals flee one country or region and end up moving to a country that they feel gives them better and more opportunities. Several common causes precipitate brain drain on the geographical, including political instability, poor quality of life, limited access to healthcare, and a shortage of economic opportunity. These factors prompt skilled and talented workers to leave source countries for places that offer better opportunities. Organizational and industrial brain drain. Organizational brain drain involves mass exodus of talented workers from a company, often because they sense instability, a lack of opportunity within the company, or they may feel that they can realize their career goals more easily at another company. Industrial brain drain happens when skilled workers exit not only a company but an entire industry. These two forms of brain drain are usually a byproduct of a rapidly evolving economic landscape in which companies and industries unable to keep up with technological and social changes lose their best workers to those that can. Causes of brain drain. So what causes brain drain? As noted above, there are several underlying factors that lead to this phenomenon. They can vary, though, based on the type of brain drain. Some of the main reasons why people choose to leave their home countries' regions include 1. Economic opportunities, including new and better jobs, higher standards of living, access to housing and health care. 1. Political strife and instability. 1. Persecution based on religion, gender, or sexuality. While most brain drain is geographic, there is some brain drain that occurs as a result of situational factors. For instance, skilled workers may leave companies and industries when machines and technology replace human labor. Effects of brain drain. Brain drain can have major consequences. The effects are felt not only in the area where the brain drain occurs but also where the brain gain, where individuals move to, takes place. And it can often have a chain reaction. Areas affected by brain drain end up with a dearth of human capital. Professionals who go else end up leaving a large hole to fill, one that isn't always easy to fill. Consider medical professionals in developing nations who move to parts of the developed world for better opportunities. There may not be enough qualified people to replace them when they leave, which affects the quality of health care for those left behind. Another effect on areas that experience brain drain is the loss of revenue. Governments rely on income taxes to fund their social programs and infrastructure projects. A mass exodus leads to a drop in taxes receipts, which can stunt economic growth and development. Areas that see brain gain are also impacted. Some of these factors include overcrowding, especially in major metropolitan areas where more opportunities are available. More people in one area puts a strain on resources, which can lead to higher prices and taxes. Measures to reduce brain drain. While there isn't an easy fix for brain drain, there are some things that business and government leaders can do to reduce or minimize it. These include 1. Increasing investments into certain areas of the economy. 1. Offering competitive wages. 1. Paving the way for legal and social reform. 1. Improving the quality of resources, such as housing and health care. 1. Providing affordable housing solutions. Examples of brain drain. Ukraine brain drain. War and conflict are big catalysts for brain drain. This was evident following Russia's invasion of Ukraine. Studies conducted by the European Parliament indicate a massive displacement of the country's population across the European Union, EU. One of the main areas the study examined was the movement of students. The number of students leaving Ukraine doubled from 25,000 to 50,000 between 2007 and 2014. That number has jumped to about 78,000 by 2019. The majority of these students were enrolled in post-secondary institutions in Poland. Some professionals leaving Ukraine are having a tough time finding work in their fields in other countries because of a lack of available work or transferable skills. As such, some are choosing to take on lower-paying jobs to find a sense of security and safety. But it isn't just Ukraine that's experiencing a brain drain. In fact, Russia is experiencing a flight of human capital too. Economic sanctions placed on the country by the US, the United Kingdom, and Canada are having a profound impact on Russian citizens. The federal government also has laws in place punishing citizens who support Ukraine. It's estimated that as many as 200,000 Russians left the country. Puerto Rico brain drain. Brain drain was a significant consequence of the ongoing Puerto Rican debt crisis as of 2019. This was particularly evident in the exodus of skilled medical professionals, which hit the island hard. While almost half of Puerto Rico's residents receive Medicare or Medicaid, the island receives significantly fewer federal funds to pay for these programs than similarly sized states on the mainland such as Mississippi. This lack of funding combined with the island's dire financial situation prevents its ability to offer competitive compensation to doctors, nurses, and other medical staff. As a result, such professionals were reported to be leaving the island en masse for more lucrative opportunities on the mainland. This form of brain drain was also exacerbated by Hurricane Maria, which hit the island in September 2017, creating even more incentives for immigration. What does brain drain mean? Brain drain is a slang term that alludes to the loss of human capital from one area to another or from one industry to another. Brain drain usually happens when skilled individuals and professionals leave the home countries, in most cases, developing nations, and go elsewhere to take advantage of better opportunities. It also occurs when individuals leave one area of the workforce and go to another for some of the same reasons. How does economic growth help fight brain drain? Brain drain occurs when there is a lack of opportunity in a certain area. For instance, professionals living in a developing nation may leave in search of better opportunities in parts of the developed world. Making economic investments to boost growth often provides incentives for people to stay, as it means access to better, and more, resources, personal economic prosperity, and the potential for a higher standard of living. What impact does brain drain have on developing nations? Brain drain or the exodus of human capital often has a big impact on developing nations. It often leaves a hole that is hard to fill since there may not be as many people with similar skills to fill that void. It also leads to a loss in tax revenue, which can lead to higher taxation to make up for the shortfall. Citizens may not be able to access quality resources, such as education and healthcare, which also affects their quality of life. The bottom line: human capital is a vital part of the economy. But when conditions get tough, these individuals may look elsewhere for better jobs, higher pay, and an improved standard of living. A mass exodus of people can lead to what's called brain drain. When human capital is depleted from a certain area, it can have lasting effects on the local economy. Explain the dichotomy between secularism vis-a-vis religious freedom. During the inception of the Constitution of India in 1950, the preamble did not contain the words socialist and secular. These words were added to the preamble through the 42nd Amendment Act, in the year 1976. Prior to this amendment, the Supreme Court in Keshwananda Bhattav, State of Kerala, held that the preamble is a part of the Constitution and it can be amended but subject to the condition that the basic features of the preamble cannot be amended. With the Bharatiya Janata Party coming to power in the year 2014, one word which is revolving in and around every person's mind is secular. Though prior to that, there were major changes that changed the demography of this country under the umbrella of secularism, but with a rise of a Hindu nationalist party, it is being alleged by the minority section of this country that their religion is under immense danger, and this has resulted in tremendous intolerance in the country. Analyzing the current scenario in the country, the research paper tries to portray the secularism existing in India in the light of the plight of millions of Hindus who have been the victim of this rising intolerance. The research paper concludes with certain suggestions which can be considered for establishing a balanced secular society and thus enshrining the goals of the Constitution. Introduction. India is often accredited with the term melting pot of diversity, due to the presence of many religions within the country. In light of this religious diversity, independent India has proclaimed secularism to be one of its key policy values and thus declaring itself as a secular state by the insertion of the word secular in the preamble. D. E. Smith opines that a secular state is a state which guarantees individual and corporate freedom of religion, deals with the individual as a citizen irrespective of religion, is not constitutionally connected to a particular religion nor does it seek either to promote or interfere with it. The secular state views its individual as a citizen and not as a member of a particular religious group. Religion becomes entirely irrelevant in defining the terms of citizenship. Its rights and duties are not affected by individual religious beliefs. Article 25 of the Constitution of India allows any individual the freedom of conscience and free profession, practice and propagation of his/her religion. This article forms the bedrock of secularism in India. Accordingly, every person is allowed to practice his religion. The religious demography, before the advent of Islam, was to very extent stable, with only few religions residing. With the advent of Islam, not only a new community established but certain religions in order to counter this new religion of brotherhood also came into existence due to the growing atrocities against Hindus. This situation got somewhat stable with the coming of Britishers, but the situation started deteriorating again with the divide and rule policy that was adopted by Britishers. After independence, the situation with regard to communal clashes started getting worsen. And with India entering the 21st century, the secularism in India started taking a different turn altogether. Though the beginning of this change started around 1990s with the enactment of Places of Worship Act in 1991 to prohibit the conversion of any place of worship and requiring the preservation of any place of worship's religious character as it existed on 15 August 1947 and the demolition of Babri Masjid, which was allegedly to be constructed after demolishing the temple of Lord Ram. Prior to all these, from 1989 onwards, mass exodus of Kashmiri Pandits had begun from Kashmir. If one tries to analyze these incidents, prima facie it appeared that the secularism in India for Hindus had become a hoax and they were always subject to a situation of compromise. Year after year, the faith of Hindus was made a joke, and with the coming of Bharatiya Janata Party into power in 2014 and again in 2019, the faith of Hindu has been termed a new word, i.e. intolerance, by the liberal section of this country. Secularism in India. The Hindu ethos is prevalent in India. Hindus make up the bulk of the population. It is ingrained in the culture to respect all forms of thinking, belief, and worship. Minority sects would have had complete inequality even if the constitutional protections had not been in place. This is in contrast, our Muslim-majority neighbors Pakistan, Bangladesh, Afghanistan, and the Middle East's Iran, Iraq, Jordan, Saudi Arabia, and others have proclaimed themselves Islamic republics or kingdoms and have refused Hindus religious freedom by law and practice. If one tries to trace the incidents from the time Islamic invaders invaded India and especially after independence, it appears that under Islamic rule, the religious sentiments of the Hindus became the victim of the aggressive conversion policies of the Islamic rulers. Thousands of temples, including certain temples of the utmost importance in the Hindu religion such as at Ayodhya, Kashi, Mathura, Somnath and many others were attacked and illegally demolished, and at certain demolished sites, mosques were even constructed. What surprises most is the situation which supposed to have improved worsened after independence. Minor incidents of temples being demolished and lynching of Hindus were reported from various parts of the country. Post-independence, it was in 1976, the Indira Gandhi government decided to insert the word secular to the preamble, which was left out by the constitution makers. But one prominent question arises after this amendment, i.e. did the insertion of secular imply that India had not been secular before 1976? Had the omission of the word turned India into a Hindu Rashtra? The answer to these questions is no. The fathers of the constitution made it incumbent on Hindus to note their devotion to the Upanishadic ideal of Vasudhaiva Kutumbakam by leaving the term out of the preamble. So, secularism in the Indian context would not mean the state remaining away from religion. Instead, it would mean maintaining independence from all religions. Unfortunately, that equidistance never happened. Over the years, the test of secularism came to be whether India's minorities perceived an action as secular or not. For example, the government gave itself very little day-to-day control over the Central Waqf Council or over Christian institutions, but soon exercised incredible control over Hindu temples. Nehru decided to pass the 4 Hindu code bills while abandoning the objective of a uniform civil code. Even in politics, seeking Muslim votes by appealing to the Imam of Jama Masjid was considered smart, but appealing to Hindu seers was communal. Religious interference and temple destruction. The repeated aggressions of radical Islamists and Christians has pushed the Hindus into a state of victimhood. Continuous assault over the religious sentiments of the Hindus has not only destroyed the thread of unity among Hindus but also the destruction of thousands of temples. The history is full of such incidents of destruction of temples. For example, the Somnath temple. The temple was first desecrated in 725 CE by Al-Junayd, the Arab governor of Sindh. After being repaired, it was destroyed during Mahmud of Ghazni's invasions in 1025. It was repaired, but Alauddin Khilji destroyed it again in 1299. The temple was rebuilt only to be demolished in 1395 by Zafar Khan, the Muslim governor of Gujarat. The Sultan of Gujarat, Mahmud Bigda, desecrated it in 1451. In 1665, Aurangzeb dealt the final blow when he tore it down. Such incident of demolition of temples can also be found in the 3 holy sites of Ayodhya, Mathura and Kashi. Fortunately, the dispute in Ayodhya took a legal turn and was instituted in the court as a suit which took years to be resolved. In 1992, the Babri Masjid, which was built over Tehranjan Mabhumi, was demolished by Hindus. Fortunately, another title suit was instituted in the court, and in 2019, the apex court granted the disputed site to Hindus. Though the Ayodhya dispute has been resolved, Mathura and Kashi are still waiting to get justice. The beginning of construction of Ram Temple at Ayodhya also faced backlash from the secular group of the country for not constructing hospitals or other public infrastructure. But such criticisms were not made while during construction of mosques in different parts of the country. Apart from these prime religious sites, today also, Idols of Hindu gods and goddesses are destroyed and religious sites are being desecrated by people from minority groups. In addition to this, despite constitutional provisions, state governments have been regulating and regularly taking over Hindu temples, while mosques and churches are permitted to be governed exclusively by their respective communities, despite Article 26 conferring the right on all people equally. Furthermore, state control of temples is doubly harmful to Hindus in that they have not only lost control of their temples to the government, but they have also become a part of the state, as per Article 12 of the Constitution as a result of that control. As a result, centuries-old religious rituals, festivals, and traditions are selectively and unduly questioned and interfered with. In addition to this, in 1991, the P.V. Narasimha Rao government enacted the Places of Worship Act, in the backdrop of growing agitation by right-wing groups regarding the reclamation of 3,000 mosques which were built by destructing temples. The Act aims to freeze the status of places of worship as they were on 15 August 1947. The law kept the disputed structure at Ayodhya out of its purview, mainly because it was the subject of prolonged litigation. It was also aimed at providing scope for a possible negotiated settlement. This law again hurt the religious sentiments of the majority population, because in the name of secularism, the mosques were given security from being demolished, as history is full of examples where temples have been demolished and mosques have been built over them. Human rights violations. Gross human rights violations has been taking place from the day Islamic invaders came to India. In the name of conversion, several people were looted and killed and women were raped. During the British Raj, due to the divide and rule policies, there were constant communal clashes. In post-independent India, these clashes were exaggerated further and the primary victim of this exaggeration were the Hindus. Mob lynching cases were reported from all over the country. But something more severe took place in the 1990s. In 1990, India saw one of the largest exoduses of a community fleeing its homeland from fear of being persecuted. 5. The number of people who fled remains debated, with few authors stating it ranged from 1 lakh to 1,40,000 to as high as 8 lakhs. Religious and ethnic triggers, as well as external influences, seem to have played a role in the incident. The Hindu community was disappointed, believing that they were not treated fairly because they were a minority. Many factors contributed to Hindu-Muslim tensions, including the construction of a mosque on the Secretariat grounds. This attracted the resentment of many Hindus. As a result, several temples were demolished, including those in Anantnag, causing widespread havoc. The genocide that began in the valley was targeted towards the minority community residing there, i.e. the Kashmiri Pandits, and the primary reason is that these people follow a particular religion. Thousands of people were made refugees in their own country, many were looted and killed and women were raped. But unfortunately, there was no crackdown on these gross human rights violations. Hopefully, the abrogation of Article 370 and 35-A has started attracting the Pandits back to the valley. In 21st century, mob lynching of Hindus and no action against the culprits has become a daily affair of the country. Whether it is the Palghar lynching case, or of common people in the name of conversion, the government has become a mute spectator. What is surprising is Hindus are being lynched just because of supporting a particular party. The state of West Bengal is reporting such incidents in large numbers where the goons of the ruling TMC government are killing supporters of the BJP. The post-poll violence appeared a genocide-like situation where these goons not only killed BJP workers but also damaged properties and also assaulted and raped women. The prime target of these incidents of violence were Hindus just because of following a political party with a Hindu ideology and religion. The issue of love jihad has also become a center of discussion. Many Hindu women are lured to marry by the men from other religion and after marriage are forced to convert to the religion of their husband. The refusal to convert brings torture and at times death for the women. Such incidents have been termed as love jihad by the Hindu right-wing groups. States like Uttar Pradesh, Madhya Pradesh and Uttarakhand have enacted laws to curb such incidents of love jihad. Such laws have been termed by critics as against the fundamental rights of citizens, especially Article 25. But the fact is, women not only from Hindu religion but also from other religion are lured to marry later are forced to convert and if the women refuse, she is assaulted and at times killed. However, most of the victims are from Hindu religion. During such incidents where a woman from the majority population is the victim, none of the human rights activists come out in support of such victims. Hopefully, the love jihad laws would be helpful in curbing such cases with regard to women from all the religion. Appeasement politics. The nation's political parties have passionately opposed the secular state's strategy. They combine religion with revenge in politics and toss ideals into the open. Religion is nothing more than a dead ritual if it lacks ideals such as justice, equality, compassion, love, non-violence, truth, and sensitivity to other people's suffering, and it can be very dangerous if faith is synonymous with hollow rituals rather than beliefs, as our politicians do. This has been the case since the country's independence. The Indian politics has been commercialized. Politicians, rather than focusing on achievements, focus more on branding themselves with religious groups which are considered as the dominant religious groups in the region. This branding is termed as appeasement politics. Whether it be the regional parties or national parties, minority appeasement is the first method to grab votes. Post-independence, every election has seen appeasement of minority religions. Be it granting monthly salary to imams or welfare projects for minority groups or trips to Hajj, the welfare of Hindus during these appeasement politics is the last thing done. A recent example is during the election of the state of West Bengal. The TMC government increased the salary of imams, offered namaz and did what not to appease the minority sections which form a good chunk of the state's population. However, seeing the BJP conducting an aggressive campaigning through its top leaders for grabbing votes of Hindus, the TMC Supremo Mamata Banerjee turned herself towards appeasing the Hindus by performing Chandi Path. Similar instances of appeasing Hindus just before election has been done by several other chief ministers by arranging Tirth Yatras programs just before elections. The Prime Minister himself offered scholarships for students from minority community. Conclusions and suggestion. Every invasion of India by an alien religious and cultural community, according to Gajendra Ducker, J., resulted in conflicts and forcible conversion for a short period of time. But, in the end, they settled down peacefully and contributed to Indian society in different ways. This, he says, is due to the Hindu religion's omnipresence of tolerance and liberal nature, which provides the theological foundation for the philosophy of secularism in India. India's constitutional scheme guarantees equality in matters of religion to all religions, to all people and classes, regardless of faith, emphasizing that the state has no religion. The preamble of the Constitution, when read in conjunction with Articles 25 to 28, exemplifies this point and shows that secularism is enshrined in our Constitution in this way. With the Bharatiya Janata Party coming into the power, the Hindus found a ray of hope for raising their voices and to some extent even did. But the liberals of this nation termed this as religious intolerance towards minority communities. A new trend has emerged that whatever the ruling government does, it is for Hindus and only they should be blamed for it. Due to this, for every act of government, the common Hindu mass is being abused who has no role to play in the acts of the government. There is a strong need to curb this growing aggression against the Hindus and achieve the goals of secularism as enshrined in the Constitution. The first and foremost thing is to bring a uniform civil code. This will provide a basic foundation to reorient the policy of secularism as there would be a singular law for civil purposes such as marriage, adoption, etc. instead of numerous personal laws. Secondly, there should be a curb on the appeasement politics. Political parties focus more on appeasing the religions which are dominant in a particular region. This is despite the ruling of the Apex Court in S.R. Bommai v. UI, wherein the court states that political parties or the group of individuals who aspire to hold public posts must abide by the provisions of the Constitution. They should not mix religion with politics and respect the fundamental of secularism. The policies of the government should be focusing on particular religion but on the population as a whole. Thirdly, a committee should be formulated independent of political interference to look into the matters of mob lynching and human rights violations including the cases of love jihad and ensure that such cases are exclusively investigated by the CBI. Lastly, restoration of temples and allotment of alternate sites to Muslims for construction of their mosques and allow them to profess their faith peacefully. In the end, the words of Shashi Tharoor are worth mentioning to understand the Indian secularism. He says, Western dictionaries define secularism as the absence of religion, but Indian secularism does not mean irreligiousness. It means profusion of religions. Explain doctrine of separation of powers. Legislative power. Congress as the sole power to legislate for the United States. Under the non-delegation doctrine, Congress may not delegate its law-making responsibilities to any other agency. In this vein, the Supreme Court held in the 1998 case Clinton v. City of New York that Congress could not delegate a line-item vote to the President, by which he was empowered to selectively nullify certain provisions of a bill before signing it. The Constitution Article I, Section 8, says to give all the power to Congress. Congress has the exclusive power to legislate, to make laws and, in addition to the enumerated powers, it has all other powers vested in the government by the Constitution. Where Congress does not make great and sweeping delegations of its authority, the Supreme Court has been less stringent. One of the earliest cases involving the exact limits of non-delegation was Wayman v. Soithard, 1825. Congress had delegated to the courts the power to prescribe judicial procedure. It was contended that Congress had thereby unconstitutionally clothed the judiciary with legislative powers. Executive power. Executive power is vested, with exceptions and qualifications, in the President by Article II, Section 1, of the Constitution. By law, President becomes the Commander-in-Chief of the Army and Navy, militia of several states when called into service, has power to make treaties and appointments to office with the advice and consent of the Senate, receive ambassadors and public ministers, and take care that the laws be faithfully executed. Section 3. By using these words, the Constitution does not require the President to personally enforce the law, rather, officers subordinate to the President may perform such duties. The Constitution empowers the President to ensure the faithful execution of the laws made by Congress. Congress may itself terminate such appointments, by impeachment, and restrict the President. The President's responsibility is to execute whatever instructions he is given by the Congress. Congress often writes legislation to restrain executive officials to the performance of their duties as authorized by the laws Congress passes. In vis-a-vis. Chapter 1983, the Supreme Court decided the prescription for legislative action in Article I, Section 1 requiring all legislative powers to be vested in a Congress consisting of a Senate and a House of Representatives, and Section 7 requiring every bill passed by the House and Senate, before becoming law, to be presented to the President, and, if he disapproves, to be repassed by 2/3 of the Senate and House represents the framers' decision that the legislative power of the federal government be exercised in accord with a single, finely wrought and exhaustively considered procedure. This procedure is an integral part of the constitutional design for the separation of powers. Further rulings clarified the case. Even both houses acting together cannot override executive vetoes without a second-march majority. Legislation may always prescribe regulations governing executive officers. Judicial power. Judicial power, the power to decide cases and controversies, is vested in the Supreme Court and interior courts established by Congress. The judges must be appointed by the President with the advice and consent of the Senate, hold office for life and receive compensation that may not be diminished during their continuance in office. If a court's judges do not have such attributes, the court may not exercise the judicial power of the United States. Courts exercising judicial power are called constitutional courts. Congress may establish legislative courts, which do not take the form of judicial agencies or commissions, whose members do not have the same security of tenure or compensation as the constitutional court judges. Legislative courts may not exercise the judicial power of the United States. In Murray's Lessee v. Hoboken Land and Improvement Co., 1856, the Supreme Court held that a legislative court may not decide a suit at the common law, or in equity, or admiralty. As such, a suit is inherently judicial. Legislative courts may only adjudicate public rights. Even though above all, separation of powers is not accepted in America in its strict sense, it has only attracted the makers of most modern constitutions, especially during the 19th century. In a leading case, Marbury v. Madison, is a landmark case in United States law. It is formed the basis for the exercise of judicial review in the United States under Article 3 of the Constitution. This case resulted from a petition to the Supreme Court by William Marbury, who had been appointed by President John Adams as Justice of the Peace in the District of Columbia but whose commission was not subsequently delivered. Marbury petitioned the Supreme Court to force Secretary of State James Madison to deliver the document, but the court, with John Marshall as Chief Justice, denied Marbury's petition, holding that the part of the statute upon which he based his claim, the Judiciary Act of 1789, was unconstitutional. Marbury v. Madison was the first time the Supreme Court declared something unconstitutional, and established the concept of judicial review in the U.S., the idea that courts may oversee and nullify the actions of another branch of government. The landmark decision helped define the checks and balances of the American form of government. Separation of powers has again become a current issue of some controversy concerning debates about judicial independence and political efforts in increase the accountability of judges for the quality of their work, avoiding conflicts of interest, and charges that some judges allegedly disregard procedural rules, statutes and higher court precedents. It is said on one side of this debate that the separation of powers means that powers are shared among different branches. No one branch may act unilaterally on issues, but most obtain some form of agreement across branches. That is, it is argued that checks and balances apply to the judicial branch as well as to the other branches. It is said on the other side of this debate, the separation of powers means that the judiciary is independent and untouchable in the judiciary sphere. In this view, separation of powers means that the judiciary alone holds all powers relative to the judicial function, and that the legislative and executive branches may not interfere in any aspect of the judicial branch. The doctrine of separation finds its home in the U.S. It forms the basis of the American constitutional structure. Article I vests legislative power in Congress, Article II vests executive power in the President, and Article III vests judicial power in the Supreme Court. The framers of the American Constitution believed that the principle of separation of powers would help to prevent the rise of tyrannical government by making it impossible for an exercise group of persons to exercise too much power. Accordingly, they intended that the balance of power should be attained by checks and balances between separate organs of the government. This alternative system existing with the separation of them prevents any organ from becoming supreme. Despite of the express mention of this doctrine in the Constitution, U.S. incorporates certain exceptions to the principle of separation with a view to introducing a system of checks and balances. For example, a bill passed by Congress may be vetoed by the President in the exercise of his legislative power. Also, treaty-making power is with the President, but it's not effective till approved by the Senate. It was the exercise of executive power of the Senate due to which the U.S. couldn't become a member the League of Nations. The Supreme Court has the power to declare the acts passed by Congress as unconstitutional. There are other functions of an organ which are also used by others. India, too, followed U.S. in the adoption of the checks and balances which make sure that individuals' organs don't behold powers absolutely. This means that the functioning of one organ is checked by the other to an extent so that no organ may misuse its power. Therefore, the Constitution, which gives a good mention of the doctrine in its provisions, also does not follow it in its rigidity and hence has opted for dilution of powers just like India. Separation of powers and the Indian Constitution. The constitutional history of India reveals that the framers of the Indian Constitution had no sympathy with the doctrine. This is evident from its express rejection in spite of attempts being made. It even sheds no light to the application of the doctrine during the British regime. The Constituent Assembly, while in the process of drafting the Constitution, had dwelt at length for incorporating the doctrine and ultimately rejected the idea in toto. Dr. B.R.A. Ambedkar, who was one among the members of the Constituent Assembly, while comparing the parliamentary and presidential systems of India and America respectively, remarked thus: looking at it from the point of view of responsibility, A non-parliamentary executive, being independent of parliament, tends to be less responsible to the legislature, while a parliamentary system differs from a non-parliamentary system in as much as the former is more responsible than the latter, but they also differ as to time and agency for assessment of their responsibility. Under the non-parliamentary system, such as the one that exists in the USA, the assessment of the responsibilities of the executive is periodic. It takes place once in 2 years. It is done by the electorate in England, where the parliamentary system prevails. The assessment of responsibility is both periodic and daily. The daily assessment is done by the members of the parliament through questions, resolutions, no confidence motions, adjournment motions and debates on address. Periodic assessment is done by the electorate at the time of the election, which may take place every 5 years or earlier. The daily assessment of responsibility, which is not available under the American system, it is felt, far more effective than the periodic assessment and far more necessary in a country like India. The draft constitution, in recommending the parliamentary system of government, preferred more responsibility than stability. The above view of Dr. Ambedkar thus substantiates that the Indian constitution does not make any absolute or rigid separation of powers of 3 organs owing to its pro-responsibility approach, rather than having stability at the center stage. This has, however, been further supplemented and reiterated by the Indian Supreme Court. In Ram Javaya Kapoor v. The State of Punjab, the court though Mukherjee held that the Indian Constitution has indeed not recognized the doctrine of separation of powers in its absolute rigidity, but the functions of different parts or branches of the government have been sufficiently differentiated, and consequently, it can very well be said that our Constitution does not contemplate the assumption, by one organ or part of the state, of functions that essentially belong to another. A more refined and clarified view taken in Ram Javaya's case can be found in Katar Singh v. State of Punjab, where Ramaswamy J. stayed. It is the basic postulate under the Indian Constitution that the legal power has been distributed between the legislature to make the law, the executive to implement the law, and the judiciary to interpret the law within the limits set down by the Constitution. The functional classification and sufficient demarcation, as is held by the Supreme Court, indeed does not suggest the application of the doctrine in its absolute terms. Rather, it just gives a slight glimpse as to the character of the Indian Constitution, which is shares with the pure doctrine discussed above, that is, inter alia the acceptance of the philosophy behind the doctrine pertaining to the rigors of concentration of power and the avoidance of tyranny, of having a rule of law and not the rule of men. The same can be substantiated through a detailed analysis of the provisions of the Constitution, which is the next course of action this chapter attempts to take. The executive in India, like any other Westminster system, is a subset of the legislature, and virtually there is a fusion between them. Thus, generally no friction arises between them. The Constitution of India has indeed adopted the British parliamentary system, where the political executive controls the parliament. In addition, the cabinet or the council of ministers enjoys a majority in the legislature and virtually controls both the legislature as well as the executive. Just like the British cabinet, its Indian counterpart can be called a hyphen, which joins a buckle which the legislative part of the state to its executive part. Under the Indian Constitution, the executive powers are vested with the President and governors for respective states. The President is, therefore, regarded as the chief executive of the Indian Union who exercises his powers as per the constitutional mandate on the aid and advice of the Council of Ministers. The President is also empowered to promulgate ordinances in exercise his extensive legislative powers which extend to all matters that are within the legislative competence of the Parliament. Such a power is co-extensive with the legislative power of the Parliament. Apart from ordinance making, he is also vested with powers to frame rules and regulations relating to service matters. In the absence of parliamentary enactments, these rules and regulations hold the field and regulate the entire course of public service under the Union and the states. Promulgation of emergency situations is yet another sphere of legislative power which the President is clothed with. While exercising the power after the promulgation of an emergency, he can make laws for the state after the dissolution of the state legislature following the declaration of emergency in a particular state, on failure of the constitutional machinery. Like the British Crown, the President of India is a part of the legislature though he is not a member of any House of Parliament. No bill for the formation of new states or alternation of boundaries etc. of the existing states, or affecting taxation in which states are interested or affecting the principles laid down for distributing money to the states or imposing a surcharge for the purposes of the Union, and no money bill or bill involving expenditure from the Consolidated Fund of India can be introduced for legislation except on the recommendation of the President. Besides this, he also has powers to grant pardons, reprieves, respites or remissions of punishment or to suspend, remit or commute the sentence of any person convicted any offence which is of judicial nature. He also performs similar judicial functions in deciding a dispute relating to the age of the judges of the constitutional courts for the purpose of their retirement from their judicial office. In a similar manner, Parliament also exercises judicial functions. While performing judicial functions, it can decide a question of breach of its privilege and, if proved, can punish the person concerned. While doing so, Parliament is the sole judge and courts cannot generally question the decision of the Houses on this point. Moreover, in case of impeachment of the President, one House of Parliament acts as a prosecutor and the other House investigates the levelled charges and decides whether the House is substantiated or not. There is, however, a considerable institutional separation between the judiciary and other organs of the government. The Constitution confers wide powers. However, a certain amount of executive control is vested in the higher judiciary with respect to the subordinate judiciary. At the same time, the power of appointment of high courts and Supreme Court judges, including the Chief Justice of India, partially with the executive, that is to say, the President of India, who in turn exercises this power in consultation with the governors of the concerned states and the Chief Justice of the concerned High Court in case of a High Court judge and Chief Justice of India in case of a Supreme Court judge. Moreover, the judges of constitutional courts cannot be removed except for proved misconduct or incapacity and unless an address supported by 2/3 of the members and an absolute majority of the total membership of the House is passed in each House of Parliament and presented to the President. Apart from exercising routine judicial functions, the superior constitutional courts also perform certain executive and administrative functions as well. High courts have supervisory powers over all subordinate courts and tribunals and also the power to transfer cases. In addition, the high courts as well as the Supreme Court also have legislative powers by virtue of which they can frame rules regulating their own procedure for the conduct and disposal of cases. The foregoing exercise establishes the proposition expounded by the Supreme Court in Ram Javai's case. The analysis clearly shows that the concept of separation of powers, so far as the Indian Constitution is concerned, reveals an artistic blend and an adroit admixture of judicial, legislative and executive functions. Separation sought to be achieved by the Indian Constitution is not in an absolute or literal sense. Despite being evident that the Constitution nowhere expressly bows in line with the concept, it remains an essential framework of the constitutional scheme. Agreeing on this premise, it has also been accorded the status of basic structure by the Supreme Court. Therefore, it can axiomatically be said that the Indian Constitution does not contemplate separation as embodied in the pure doctrine, it rather perceives and accords to it in its central sense, that is to say, not in its literal sense rather in its purposive sense, i.e. non-conferment of unfettered powers in a single body of men and to motivate checks and balances. Another point of concern which requires clarification is whether the three organs, though not rigidly separate, can usurp their powers or are they required by the Constitution to work only within the respective area earmarked in a narrow sense. To put it differently, whether the Constitution mandates encroachment by one organ into the domain of another on the pretext of failure or inaction of the other organ is the next question that needs to be addressed in its context. Though theoretically, this issue has been addressed by the Supreme Court, it has failed to cater to basis in practice, which is evident from the growing amount of judicial encroachment in the domain of other organs. In Asif Hamid v. State of J&K, it has been held that although the doctrine of separation of powers has not been recognized under the Constitution, makers have meticulously defined the functions of various organs of the state. The legislature, executive and judiciary have to function within their respective spheres demarcated under the Constitution. No organ can usurp the functions assigned to another. Legislative and executive organs, the two facets of the people, will have all the powers, including that of finance. The judiciary has no power over the sword or the purse. Nonetheless, it has the power to ensure that the aforesaid two main organs of the state function within the constitutional limits. It is the sentinel of democracy. The prime point of our concern here is whether the judicial organ of the state is conferred with a constitutional mandate so as to overstep its limits while discharging its main functions. That is to say, whether the judiciary can interfere and encroach into the executive or legislative domain if it just demands so, or it cannot do so simply by virtue of the fact that the concept of separation of powers puts fetters on it. To answer these points, one needs to ascertain as to what statute the judiciary has been accorded in the Indian Constitution. Is it supreme as compared to the other organs, or is it subordinate thereto? The judiciary under the Indian Constitution has been given an independent status. It has been assigned the role of an independent umpire to guard the Constitution and thereby ensure that other branches may not exceed their powers and functions within the constitutional framework. Commenting and clarifying the concept of independence of the judiciary, Sir A.K. Iyer, who was one of the framers of the Constitution, had observed that the doctrine of independence of judiciary is not to be raised to a level of a dogma so as to enable the judiciary to function as a kind of super-legislature or super-executive. The judiciary is there to interpret the Constitution or to adjudicate upon the rights between the parties concerned. It can thus very aptly be said that the creation of the judicial organ in India was not at all meant to give it a supreme status as compared to the other coordinate organs. Rather, with powers and functions sufficiently distinguished and demarcated, what is expected out of the judiciary is to act as a watchdog to oversee and prods to keep the other organs in constitutional bounds. The essence of the Constitution is that it produces a system which is the result of amalgamation of the principles of separation of powers with the doctrine of parliamentary sovereignty in a manner to give effect to both, yet without the rigidity of the two systems. Parliamentary democracy is cemented as the cornerstone of the constitutional edifice in preference to the presidential system of governance. Separation of powers and justice pronouncements in India. In India, we follow a separation of functions and not of powers. And hence, we don't abide by the principle in its rigidity. An example of it can be seen in the exercise of functions by the cabinet ministers, who exercise both legislative and executive functions. Art. 74. 1. Wins them an upper hand over the executive by making their aid and advice mandatory for the formal head. The executive, thus, is derived from the legislature and is dependent on it for its legitimacy. This was the observation made by the Honorable SC in Ram Javaya v. Punjab. On the question of where the amending power of the Parliament does lies and whether Art. 368 confers an unlimited amending power on Parliament, the SC in Keshwanand Bharti held that amending power was now subject to the basic features of the Constitution, and hence, any amendment tapering these essential features will be struck down as unconstitutional. Beg. J added that separation of powers is a part of the basic structure of the Constitution. None of the three separate organs of the Republic can take over the functions assigned to the other. The scheme cannot be changed even by resorting to Art. 368 of the Constitution. There are attempts made to dilute the principle to the level of usurpation of judicial power by the legislature. In a subsequent case law, SC had occasion to apply the Keshwanand ruling regarding the non-amendability of the basic features of the Constitution, and strict adherence to the doctrine of separation of powers can be seen in Indira Nehru Gandhi v. Rajnarayan, where the dispute regarding the PM election was pending before the Supreme Court. It was held that adjudication of a specific dispute is a judicial function which Parliament, even under constitutional amending power, cannot exercise power. So, the main ground on which the amendment was held ultra vires was that when the constituent body declared that the election of PM won't be void, it discharged a judicial function which according to the principle of separation it shouldn't have done. The place of this doctrine in an Indian context was made a bit clear after this judgment. Though in district, separation of powers like in the American sense is not followed, but the principle of checks and balances a part of this basic structure doctrine, so much so that not even by amending the Constitution, and if any such amendment is made, the court will strike it down as unconstitutional.